The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Mr. Cooney, whenever you're ready, we'd be pleased to hear from you.
Thank you, Your Honor. If it pleases the court, I'm Jim Cooney of the Bar of the State of North Carolina, and I represent the petitioner appellant John Edward Burr. When the state charged Mr. Burr with capital murder in the death of Teresa Sue O'Daniel, a 4-month-old child, it did so on the theory that shortly after midnight on August 25th, 1991, and for reasons that have never been fully explained, Mr. Burr beat this child and inflicted a lethal brain injury on her. But in order to prove that theory, the state was going to have to grapple with 3 central issues. First of all, there were no witnesses. No one saw Mr. Burr hit, hurt, or harm that child. Mr. Burr denied it. He waived his rights. He consulted with the police, even took the witness stand at his trial. So whatever case the state was going to have to build was going to be a circumstantial case. The second issue the state had to grapple with is the fact that within the time period where this lethal brain injury could have been inflicted, there was another event that took place. This child was being carried by Scott Engel, her brother, across the yard. He was running, tripped over a cord, and initially it was described as he fell, dropped to the ground, and fell on top of it. So the state was going to have to exclude or at least minimize the fall to the extent it could be a causative factor in this lethal brain injury. The final issue the state had was when this child was brought to the hospital, x-rays revealed that this child had healing and old comminuted fractures of the arms and legs, indicating abuse that had been going on for days and weeks. And
Mr. Cooney, I hear what you're saying, but isn't that more in the nature of a jury argument, closing argument, to point out deficiencies in the state's evidence? What you perceive to be deficiencies in the state's evidence? I mean, it's a perfectly fair comment, but I wonder why it's not a simple jury argument that you've made.
I don't believe it is, Your Honor, because these deficiencies illustrate the criticality of the testimony of Lisa Bridges and Scott Engel, because it was through those 2 witnesses that the state addressed each of these issues. And it was through those 2 witnesses that the state minimized the fall and was able to imply that Scott Engel heard something that night consistent with John Burr hitting this child, and also implied that John Burr was the chronic abuser for this child, which was an important factor in getting the jury to believe he was capable of doing this. So all that evidence rested on the credibility of these witnesses, and it's that credibility that becomes challenged by the statements that were withheld.
Well, you said it all rested on the credibility of those witnesses, but aren't we faced with the finding of the state PCR court from Alamance County as to the materiality? As I recall it, the PCR court said that the evidence from Bridges was only tangentially relevant, and that the hesitation from Scott was immaterial because of the presence of so much other testimony. And I would point you to 2 things. You try to make a great deal out of the testimony of Bridges and Scott, but you are faced with contrary findings on the part of the state PCR court. And then there's the evidence which the PCR court I'm sure, found far more significant, which was Mr. Burr's own testimony. He did take the stand, and the jury was the one that was in a position to make a credibility assessment of him, and I would think quite significantly that it depended on the jury's reaction to his own testimony. And then there is the overwhelming testimony from innumerable doctors about the fact that the alternative theory that you propose, which is that the damages arose from the fall from Scott dropping the child, that was up against a broad array of medical testimony that said this did not occur from a fall. And there were multiple witnesses also at the trial who said they did not detect injuries to Susie after the fall, from supposed fall with Scott. So there's a lot of evidence there that led to the state court's finding about the materiality of any testimony from Bridges or from Scott. And I would suggest to you that that's a finding that we are not at liberty to disregard. It's critical that this comes from state court.
Yes, Your Honor, and Your Honor is exactly correct that that's a finding I need to grapple with, and I grapple with it in this way because there was, first of all, the testimony of the doctors were based in part on the descriptions of the fall provided by Scott and Lisa Bridges. You undermine their credibility.
Counsel,
yes.
Sorry, it's Judge Harris. Can I just, when it comes to the fall, let me just tell you my concern. I do feel like you're really pushing up against our earlier opinion on the ineffective assistance case. And I'm not saying, it's exactly law of the case or anything, but we did hold there that just in light of the medical evidence and the fact testimony from the witnesses on the scene, there was no reasonable possibility that a jury could have found that the fall caused the death. And in light of that, I really am struggling with how any sort of discrepancies, and we can bracket for a minute whether they're significant, but even assuming there were some discrepancies in the description of the fall, how that could be material if we're sort of staying true to our earlier decision.
Well, Judge Harris said earlier the decision was reached, and of course Judge Wilkinson was on the panel, but the earlier decision was reached in the context of a claim of ineffective assistance of counsel. So the court was exercising double deference under its review, and I don't believe the court—
They're related in a sense, to follow up on Judge Harris's point. The prejudice inquiry in an ineffective assistance of counsel claim has got to be related to the materiality finding here that the PCR court made. In other words, they may be phrased in slightly different terms, but they both go to the significance of the evidence and the part that the evidence played. So they're not unrelated in any real sense, and in a practical sense. That earlier finding, their earlier decision, and the materiality question under Brady are actually quite intertwined.
Well, Your Honor, I guess to the extent I diverge from that, it's on this, because the materiality inquiry under Brady and Kyles goes to also the credibility of the witnesses and across an array of things. And what happened is this post-conviction court chose to do kind of a point-by-point rebuttal of what was identified as favorable evidence that was withheld. Well, what the court didn't do is what Brady and Kyles teach is supposed to do. You take all the evidence in the aggregate, you consider it together, not a piece at a time. And then as Judge Wynn wrote in Juniper against Zook, you start adding and subtracting from the various burdens. So to the extent there's evidence favorable to the defense, it goes on the defense side and it gets subtracted from the state side. And we don't see that in the post-conviction court's second opinion.
I'm going to ask, and because I think this is a significant case, but here's where we are. We could spend our time delving in as you approach this case, because it does look like there's some shoehorning of the fall issue into the Brady and Napiew type claims that you present. But even if we put aside these jury findings and the state MAR findings and our early decision that Judge Harris has made, you're still left with the question of what are the aspects of this suppressed material that actually supports a Brady and Napiew claim?
That's correct.
I think that's the heart of where you have to go here. We could go back and forth. I mean, you say there were only two witnesses to the fall. There was, in fact, her cousin Rita's son who said he saw it. There were other witnesses talked about the bruises. So there you go into the weighing stuff that Judge Wilkinson say, and we can spend some time on that if we want, because I'll tell you, I've always been amazed by the genius of how these cases can move. I mean, this case, you're talking about something that happened 30 years ago, and it's still going on. So I'm amazed by that, and I don't, for one moment, pretend to say how you should proceed with it, because I know you know what you're doing on it. But I think in this particular instance, to really address the issues before us in terms of as I presented them would be helpful.
Yes. Yes, sir.
Otherwise, we're going to spend all your time talking about evidence, going back and forth. And I'll tell you, I don't see that going anywhere, but I could be wrong. But so you go ahead.
No, I appreciate the friendly advice, and let me begin with Lisa Bridges. So we have a number of things in Lisa Bridges' interview that certainly would have been helpful to the defense, and in the hands of competent defense counsel could have been used to undermine her testimony. On 4 separate occasions in her interview, she talked not only about the fact that she did not see John Burr harm the child, but she never thought he was capable of harming the child. That her first reaction each time she was confronted about what's going on with this child was to say, well, it must have been the fall. It's not John Burr. Defense counsel wasn't given that evidence. They didn't have a chance to ask that information. In addition, she admits in the suppressed statement that she'd gone around to her family and told her family, don't tell them that Susie's been crying. Don't tell them anything that she was other than a normal, happy, healthy child before August 25th. And it got to the point where the prosecutors in the suppressed statement said to her, well, this sounds like a script. And she said, well, I did it because I didn't want to look bad. And once again, it goes to who's Susie's chronic abuser. In addition, the prosecutors suggest to her that the Department of Social Services could potentially reopen the case, and she needs to be careful about her testimony. There's an extensive discussion in the suppressed statements where the prosecutors go through the evidence with her and are coaching her. Don't say that bruise was there because that bruise was inflicted in the hospital. This bruise may not have been.
I mean, don't, as far as the prosecutor's interview, don't we have some detailed findings again from the state PCR court of Alamance County? I'm quoting from it. The content of the statements, quote, demonstrates that the prosecutors were merely trying to determine the true facts and to prepare the witnesses to provide truthful testimony. And then they go on with 10 subsidiary findings toward the same end. And the district court found the same thing in this case, that there wasn't any kind of coaching or any kind of NAPU attempt to procure perjured testimony, that they were in fact doing what counsel does quite frequently, and that is just trial preparation, trying to get witness to tell the truth. And it seems to me that you're faced with adverse findings all over the place. from the state PCR court, and I worry because the case books are full of the Supreme Court telling us to respect the state judicial process, and they're per curiam reversals from refusals to do so. And so I think there's an institutional interest that we have here in paying respect to those state court findings. This is a personal matter. This is a troubling case, not necessarily as a legal matter, but I just have to say to you, and I think it's all the more admirable that you're representing your client in the able way that you are. But a lot of times these capital cases are grisly and horrific beyond belief, but this is maybe one of the saddest cases that I've sat in mutilation and bruising of a very young child. It's so sad, and I guess that goes and enhances my admiration for you to take on in a very able way what is a very sad case.
I appreciate that, Your Honor. I'm out of time.
Oh, I'm sorry. Could I ask one question that sort of goes to what you were talking about? Is that all right, Judge Wilkinson, if I ask one last question?
It certainly is all right.
Okay. Just one. So you were talking about parts of the transcript where, you might be able to make a case that Lisa Bridges was not being really honest about the degree to which she understood there had been some prior abuse of the baby. And I guess my question is, even if that were true, so fine, the jury thinks that she, is not being entirely straight about how much she knew about what was going on before. Can you explain to me why that would have mattered so much? Wouldn't the jury still, in a case like this? I mean, there was no alternative account that sort of put her, I guess my question is, so what? And I don't mean to be flip at all. I agree with Judge Wilkinson. It's a really sad case. But I could imagine as a juror thinking, this woman probably did have some inkling of what was going on, but that doesn't mean she did it and that the defendant didn't. And in the Brady cases where the court has said that this kind of impeachment evidence is material, it's because if you disbelieve the witness, the case is over. That's the only evidence. It's eyewitnesses. As you said, this is not an eyewitness case, but the Supreme Court's Brady cases on impeachment, it's all eyewitnesses who say, I was there, I saw the defendant do it, and then it turns out there's reason to disbelieve that testimony. And I guess I should stop talking and let you answer. I'm sorry.
Oh, no, that's quite all right, Judge Harris. So the importance of this isn't that she didn't suspect what was going on. The importance of this is he wasn't the abuser to begin with. And it goes to that thing that prosecutors say they don't have to prove, but they really do, which is motive. What would possess John Burr to inflict a beating on this child at that time and at that place? And you've got to prepare the jury that this is the kind of person that would do that. But if, in fact, either Lisa Bridges is the abuser or members of her family are the abuser instead of John Burr, and remember, the only evidence of that is Scott Engel's brand new recollections just before trial that somehow he suddenly remembered John Burr shook the baby on a bed on a pillow on a few occasions. If you don't have that, or you're able to undermine that, it makes it less likely that this man out of the blue would suddenly decide, now's a good time for me to beat this child. And what it does is it both establishes, what is she covering up for? Why is she having her family lie for her? Why are they all talking from, as the prosecutors say, a script? What's going on here? And that absolutely goes to the jury's ability to find it's It can only be John Burr. I hope
Thank you.
that addresses your question.
Thank you, sir, but I'm going to ask Judge Harris if she has further questions.
Oh, thank you.
Judge Wynn, do you have any questions you would like to, further questions you wish to ask Mr. Cooney?
Not at this time, Judge. Thank you.
All right. Thank you, Mr. Cooney. You have some rebuttal time. We'd be happy to hear from you then. And Ms. Callahan, whenever you're ready, we would.
Yes, Your Honor. Good morning. May it please.
Please proceed.
Yes, sir. May it please the court. My name is Kimberly Callahan for Respondent Appellee. Susie O'Daniel died from multiple head traumas. As has already been discussed in this case, her injuries were horrific, so I won't go through each of them. But the unanimous medical opinion at trial was that her head injuries resulted from whiplash, from being shaken back and forth, and blunt force trauma that had to be so great, it was analogous to being ejected through a windshield at 60 miles an hour and hitting a tree.
It's really hard to address this case. It's so tempting to go back and try to relitigate it. Judge Wilkerson hit on something, that this is a difficult case, and the reasons he's given in terms of the victim is particularly strong. What's also strong is there's a lot of evidence in here where, as the defense counsel puts forth, you really don't have a direct witness, but you got a lot of circumstantial evidence. And the end of the day is all that's been done over the last 30 years, and I kind of understand that. And at some point in time, you got to accept the jury's verdict. But we do have these issues here, and so I think the focus, Judge Harris's last question, really goes to the focus, particularly with the Brady claim, and then you have the Napu claim here, insofar as where are we in this proceeding now, and would this have made a difference? So if you will approach the issues in this case, I think that we've been sensitized enough in terms of exactly what the facts were in this case. Well, not exactly, but really a strong indication. They're horrible. We could spend our time going back on whether the fall made a difference, whether or not he was wrong, and touching on a lot of policy issues. But we've got these couple of issues here, and I'd like to hear you address them directly in terms of how the defendant has presented them.
Certainly, Your Honor. If you look at defendant's Brady claim, it's based on the undisclosed interview concerning Lisa Bridges and Scott Ingalls. He first mentions that she states in that interview that she never saw Johnny hurt Susie and didn't think he would do it. Well, she said that at trial as well. It's on page 2076 of the joint appendix. Her 1993 interview is consistent with her trial testimony. The state court reasonably found that the discrepancies between the interview that was undisclosed and her trial testimony were de minimis. And counsel hasn't shown that that's incorrect by clear and convincing evidence.
Tell me, what is your position on the fact that the transcripts weren't released until 2015, and you consented to their inclusion on the Rule 7 below? And so are you saying we can't consider those records, or do you still agree that we can?
I would agree that you can and should look at them. I would also say that it wouldn't change the deference that is given to the state court here, because while the transcript of this other statement was not produced until 2015, it doesn't show any new evidence. It doesn't fundamentally alter his claims. And I think he said that in his motion to expand the record. So it doesn't change the deference, and it doesn't show that the state court's findings were unreasonable here. So while they certainly didn't have this transcript at the time, the substance of what's contained in this transcript was before the state court with these other interviews. There's nothing new.
In this connection, is the Martinez case relevant because we often see after the PCR ruling, we often say, well, there's this that came to light, or the PCR court didn't have a chance to do this, and Martinez, I think the Supreme Court said, well, when you keep putting in this evidence, which contributes to the incredible length of these proceedings, there has to be a fundamental alteration of the claim, not just some embellishment of it. And I was wondering if that isn't an important decision here.
Yes, Your Honor, I would say that it is, because this does not fundamentally alter his claim. This substance
Test, isn't it? The fundamental alteration test.
Yes, Your Honor. And it doesn't alter here. There's nothing new in this 2015 transcript for anybody to consider. It's cumulative. It's what she testified to at trial. It's what's included in her 1993 interview that was disclosed during post-conviction. There's no aha, oh, if I had this piece of evidence, it would have, fundamentally altered his claim. It doesn't. It simply doesn't. And so I think you can consider it, but it doesn't change the standard. Still have some deference to the state court because it doesn't make the state court's findings unreasonable in light of this transcript.
Approach this case and perhaps differently. Typically by this stage, we are not really grappling with factual determination. Judge Wilkerson again pointed that out. Usually in a death penalty case, there's no question that something happened and what he did it. We are dealing probably with sentencing issues of whether he should get life or get the death penalty. So it's a different posture when you get in. But at this point, we've just not let go, even though they're not directly with us, and certainly the statute doesn't allow us to. The merits of the case, and that's what's being touched on here with the Brady is there's some more evidence here in what the defendant certainly believes is a very close case. Whether we characterize it close or not close, we're still talking about it to the extent that we really are talking about the merits of it, not the type of sentence one should get. Given our history in terms of how we've approached death penalty cases, they do get special rules. They do get special attention. The average case, you can't keep going this long. I don't care what you do. But a death penalty case, we approach with a great deal of circumspection. So when we are confronted with this, the question then become, well, it's at some point in time you wonder what would happen if you simply just says, okay, we'll look at it and determine if it would make a difference, that sort of thing. I mean, what my question is, you think this is a different type of case, this type of death penalty case, or do you think they all fit in the same cookie cutter?
Well, certainly, Your Honor, the death cases are different. But I think if you look at this case, no matter how you look at it, the state did not violate Brady. The trial court, the state MAR court, did not unreasonably find the facts here or apply the law. And I think if you look at the evidence that was presented at trial with regard to Lisa and Scott, it counters his claims that this material was Brady. I think what he would want to get before the jury are basically the prosecutor's statements that were made in these interviews where they were prepping their witnesses, not her actual testimony.
On the Brady claim, you stand on both the question of whether it's exculpatory and the question of whether it's material. Am I correct?
Yes, Your Honor.
I just wanted to make sure. I mean, there's several prongs to Brady. It doesn't require good faith or bad faith, but it does require that the evidence be exculpatory, and it does require that the evidence be material. And as I understand it, you're standing on both prongs.
Yes, Your Honor. If you look at Lisa's testimony, if her credibility was the sticking point of petitioner's claim, if you look at her trial testimony, it is consistent with her 1993 interview. If they wanted to impeach her testimony regarding the fall or any other thing that she testified to, they had earlier interviews from 1991 where she gave somewhat inconsistent statements about the circumstances of the fall, whether he actually dropped her or fell on her. She had statements where they had statement from Scott. His 1991 interview said he did drop her. So if this is the central claim to their Brady argument, was that there's discrepancies between the descriptions of the fall. The defense counsel had that information, and in fact, it was so the evidence at trial was so overwhelming that there was no fall that caused these injuries, that the defense counsel repeatedly conceded in his case in chief and in closing argument that the fall with Scott did not cause Susie's injury. That was not the central issue at trial, and it's not relevant.
What was the central issue? Was there an alternative theory put forth? The alternative theory that's developed over time has been that it was the fall from Scott. You say it wasn't an issue at trial. What was the issue? Was it simply this gentleman's credibility?
The issue at trial was who inflicted the mortal wounds on Susie. And the defense argued that the state did not meet its burden to prove beyond a reasonable doubt that it was Mr. Burr. The fall was not considered to be even relevant, according to the defense's own statements at his trial. Because the medical evidence, and as you pointed out, the testimony from witnesses, the testimony from Burr himself said that after this fall, there was no visible signs of bruising or any type of injury on Susie. So the fall was not a central part of the trial. It was who committed these mortal wounds.
Hold on, Judge Harris. Judge Harris has a question for you.
Thank you. So I understand what you're saying about the fall, and I agree with you that that's really the thrust of the Brady claim in this case. But there is, I think, this additional claim that, well, putting to one side the fall, the transcript just undermines Susie Bridges' credibility, kind of generally. And that's enough to sort of throw into question a lot about what's going on here in a kind of an atmospheric way, I guess. Just that if she's not credible, that's a problem. And that's something the defense should have known about. Can you address sort of the credibility end of this?
Well, the defense, they've not pointed to what evidence makes her so incredible.
Well, I guess I don't want to put words into the defendant's mouth here, but I think why don't we start with the part where it really does seem like even the prosecutors think she's running around telling her family, whatever you do, don't let on to the fact that Susie had injuries before this. Act like everything was fine until this day.
Certainly, Your Honor. So what the prosecutors were doing, they were coaching their witnesses. When they press Lisa about this subject, they say, this is not believable. Your story doesn't add up.
I totally agree with you that on the NAPU side of things, I read the transcript. It looks to me like the prosecutors are begging her to testify truthfully and that they don't think it's going to hold up if she keeps saying, no, nobody had any idea there was a problem until the night this happened. But that does raise a question, I think, about her credibility, given that until that time, she is trying to pretend there was no problem until the night of the crime.
And Your Honor, I point you back to trial testimony that she said the exact same thing at trial. She said, I did not believe that Burr was going to hurt her or hurt my children.
Okay. Yeah, no, that seems like a slightly separate question. I understand what you're saying on that too. I guess what I'm trying to get at, and this may not, in the posture we're in, I'm not 100% sure it matters, but if I thought from reading that transcript that Lisa Bridges appears to have been asking family members, perhaps to even testify untruthfully about Susie's status before the night in question, does that call into question her credibility in a way that would be material to the outcome of this case?
If perhaps, Your Honor, that's actually what she said. Now, I don't have the page marked, but from my understanding of the transcript, the prosecutor, what she actually said was, I told my family not to tell the people that Susie was crying all the time because it'll make me look bad. Right. It wasn't that I asked my family to lie for me and cover up this abuse that I knew was going on. She remains steadfast at trial and at every interview that she did not think Burr hurt Susie until she got to Chapel Hill. And doctors told her this had to have been a child abuse case. She never wavers in that testimony and at trial or any of her pretrial interviews. So perhaps it would be a different case if she said, yes, I'm telling my family members to lie on my behalf. But that's not actually what we have here. She says,
in this regard, about the whole issue of prior abuse, is it relevant here that multiple witnesses say that they did not detect any injuries to Susie after the fall with Scott? That would seem to me that witness testimony would seem to me to cut substantially against any allegation of prior abuse when you say, no, we've got these witnesses here that did not detect these injuries after the fall with Scott. And that would surely be relevant to the question of prior abuse, wouldn't it?
Absolutely, Your Honor. Not only do we have witnesses, we have the petitioner himself testifying that after the fall, Susie was fine. He even went so far to say, as she was sitting on the front porch with Lisa and was smiling at him as he drove by on the lawnmower.
And you have multiple witnesses testifying to that. But in addition, as I recall it, the medical testimony, which was cumulative and quite substantial, was that what happened here was a very recent trauma. These were not, evidence of 2 or 3 years of chronic abuse, but that this was something that was fresh. And of course, there's the additional point that Burr was alone with Susie at the moment that he could have caused the death. So I think the trial did cover that question of previous abuse, at least to some extent. If there'd been conflict, if the medical testimony had said, no, this was a result of a pattern of chronic abuse, that would be one thing. But I didn't read that from the medical testimony. Did you?
I think the medical opinion was unanimous that this was inflicted injury and that it was child abuse. I don't know that there was ever a statement that this was a, quote, pattern of child abuse. I believe all of the injuries had to have occurred within 7 to 10 days of when she died. So I don't know that would be a pattern of child abuse. But you also have, Lisa's explanation as to why she didn't know that these injuries could have occurred. She was steadfast in saying, my daughter was sick, she had thrush, and she cried all the time. And so that is the reason why I did not know that these injuries had occurred prior to her death, these other broken limb injuries. The state pressed her on that. The defense pressed her on that, and she remained steadfast. That was the reason she didn't know. And the medical records support her claim in that. Just a month prior, less than a month prior, she took Susie to the hospital and got treated by Dr. Wilkinson for having thrush in her throat and ulcers in her throat. And he stated at that time There was no bruising, there was no indication of abuse whatsoever. And so you also have that explanation in these interviews and at trial as to why she didn't know that.
Excuse me, I think Judge Harris has a question for you.
Sorry, just because I see we're running short of time. I just want to ask you a procedural question. I think you suggest in your brief that we shouldn't even be reaching these issues, the Brady claim, the NAPU claim, because there wasn't an objection to the footnote at the end of the magistrate judge's report where he says he doesn't have to decide these claims. Is that your position? Is this whole argument a waste of our time because these issues are waived?
No, ma'am. Yesterday, I filed an unopposed motion to withdraw that argument.
Great. Didn't get it. Thank you.
I do.
Thank you.
Let me ask you a question before you leave it. I think it's just an interesting consideration. 2254D cases, of course, have very limited review. We understand that quite well. There are exceptions, and among the exceptions would be if the record is materially incomplete. And so in this instance, we do have information that this MAR court had before it what it believed to be the completed transcripts, but in fact it did not. How does that come into play? Because it wasn't until 15 years later or so that you get this other transcript. So how does that affect our review of the 2254D matter report?
Yes, Your Honor. I agree that the 2015 transcript was not before the state court. However, going back to what Judge Wilkinson was saying is that in order to kind of open up and do a de novo review, it would have to fundamentally alter his claim, and it doesn't, because the state court had the substance. It didn't have this particular interview, but the contents of that interview, it was before the state court. There's nothing new in this 2015 tape recording. And in fact, the transcription, the written transcription that was turned over in 1998 wasn't even part of the Brady claim. This is just something that was additionally found later on and was consented to be included in the record, but there's no new information here. So it doesn't make the trial court's findings of fact unreasonable. It doesn't present this case in a new light. It doesn't fundamentally alter the defendant's claims.
Thank you.
Are there any further questions here from either of you?
No.
If not, we will we'd be pleased to hear from Mr. Cooney on rebuttal. Mr. Cooney? You need to turn on your audio, Mr. Cooney. We're not hearing you. There you go.
I'm sorry about that. Judge Wynn, if I can address your question at the outset. One of the ways in which this case can be reopened for fact-finding is if the state post-conviction court employed a materially incomplete fact-finding process. Now, we know the state post-conviction court didn't have a hearing. The state has suggested that, well, a new transcript in 2015 wasn't even part of the Brady claim. Well, it wasn't part of the Brady claim because defense counsel didn't have it. That transcript wasn't provided. The fact of the matter is the state first represented on the first motion for appropriate relief, we've got open file discovery. You've got everything. It takes a remand of the North Carolina Supreme Court and suddenly, here are these transcripts we had, but they still don't turn over all the tape recordings of all the interviews that are going on, and those don't get completed until 2015.
So how does that alter the nature of the claim? I mean, I don't understand, because I think that Bridges and Scott, as I read the transcript in its totality, were somewhat tangential witnesses, and I think our previous opinion recognized that to be such. And how does it? I don't understand how it alters anything. I mean, this is a problem. You keep these things going so far, and then whoops, now we've altered the standard of review from our normal one of deference to the MAR court into something that's very close to de novo. And I don't understand how we get there. Because I just don't, if Bridges was a central witness in this, or if her testimony had been emphatic and compelling in one sense or another, but she wasn't. And you have to have that, the state court's finding on the materiality must come into play here. And he says, in terms of the materiality, the Superior Court said that the evidence from Bridges was only tangentially relevant, and he says the same thing is to Scott. And now we're trying to take that finding about Bridges being only a tangentially relevant witness, and we're trying to make her into a central witness on behalf of a theory having to do with fall from Scott that, as Ms. Callahan pointed out, was not even at issue in the trial. And so it seems to me that we are in danger of undermining this whole standard of review that Congress and the Supreme Court have set up for us, because we still have that materiality finding. And you just can't say, all right, all of a sudden Lisa Bridges becomes the key witness, the central witness, when she simply was not. And that isn't what the trial turned on, and it wasn't what the trial could have turned on. And that, and I don't see how we get around that, and particularly while we're trying to make her a central witness on behalf of a theory which was never advanced at trial. It just seems to me we're fundamentally trying to transform and change the whole shape of the case.
Well, Your Honor, if I can respond briefly, I do. No witness at trial was examined for the length, either on direct or cross-examination, as much as Lisa Bridges. I mean, it's not even close. Her transcript at trial probably runs 2 to 3 times the size of the transcript of any other witness at trial. And I think that—
But there can be many explanations for that. And the materiality finding of the state court made depended on the doctor's testimony at great length, and it depended on Mr. Burr's testimony. And sometimes you don't want to examine the doctors at great length, because as a matter of trial strategy, the doctor's testimony is so unfavorable to the defendant's case that you want to get them off the stand as quickly as you possibly can. And so I don't go from a trial lawyer's perspective as saying that the length of an examination is necessarily correlated to the critical nature of the testimony. You see what I'm saying?
I do, Your Honor, and certainly I've been in those situations, but I can tell you the prosecutor's direct examination of Lisa Bridges also dwarfed the direct examination of any other witness in the case. She was the central witness from that perspective in the case.
Maybe you think she's a central witness, but we have the state court's finding that she was tangential. And that's a materiality finding. And we have our previous case that in its finding of no prejudice under the IAC claim reinforces that very point.
Well, again, I think you and I I understand the link between the materiality on prejudice and the IAC claim, but it's a different measure under Brady, because the issue under Brady is how could the defense lawyer have used it? How could the defense lawyer have transformed the case? It's about what ifs necessarily in Brady, in ways that the prejudice standard deals with what actually happened because of the limitations of defense counsel's decisions. And I understand I'm bound by your prior decision. So I'm not attempting to reopen that. And I'm way over my time, and I apologize, Your Honor.
It's an important case, Mr. Cooney, and I want to make sure that you have every chance to get your point of view out. Do you have some concluding comments you wish to make?
I do, I guess two. First, I direct the court to, we hadn't talked much about Scott Engel. But in terms of Scott Engel's suppressed statement, one important thing is he testified for the first time the defense counsel was hearing a trial about this beat he heard to permit the prosecutor to argue he was listening to the Burr beat the child in the next room. But if you take a look at 1630 and 1631 of his transcript, he completely undercuts that. I mean, that's totally opposite to his testimony. And again, 10-year-old children are hard to cross-examine in a courtroom, but this would have been one way to demonstrate the unreliability of this particular witness. And
All right. Thank you.
Thank you, Your Honor.
Are there any questions from either of my good co-panelists? I'm happy to wait until you asked all the questions you wish.
I have none.
I'm all set, thank you.
All right, we thank you, Ms. Callahan, and I see that you're court appointed, Mr. Cooney, and I really appreciate the fine arguments you've made and the conscientious manner in which you have prepared and presented your case. Thank you very much on behalf of the court.
Thank you, Your Honor. I appreciate that.
All right, we will prepare to move directly.
Good morning, Your Honor. My name is Duke Nare, and I represent the petitioner, Vicente Aleman, in the case. The petitioner is convinced that the Board of Immigration Appeals erred in this case because it did not consider sufficient weight to sum up the very important facts in the petitioner's case. And the central fact in this case is the daughter, the petitioner's daughter, was the entire reason for the case, the entire reason. When he received a call on October 9th of 2015 to go get to retrieve his daughter from the police station, he was asked to file a police report. He was told, if you don't file a police report, we're not going to let your daughter go. And that is the reason why the whole case started. And when he filed that police report, his life became hell. Then he was subsequently threatened, and he was threatened again. And it's because of that they were here today. And so this fact is so important that in our respectful submission, the court will overcome the argument the appellee is making in their brief, which is the objective record. They're focusing mainly sometimes on the indictment document. But the reason why we're here It's because of the daughter. It's because of the daughter. And therefore, the Board of Immigration Appeals has erred in this case. You see, an applicant for asylum need not show conclusively why persecution occurred in the past or likely to occur in the future.
Counsel, it seems to me the critical issue here is whether there was persecution. And there clearly was no persecution on the part of the state. This is a question of an interaction of private actors. The state is not involved in any persecution. And when you're talking about private actors, you're talking about the question of whether the authorities in El Salvador were unable or unwilling to protect the petitioner. And in a private case, as opposed to a state persecution case, that becomes the question. And then it becomes the question of whether there was evidence to support the BIA's decision and whether it could have reached, or any reasonable fact finder could have reached the decision that it did. And I think we'd all be happy to hear from you on that point.
And there's ample evidence in this case to show that the government of El Salvador was completely unable and willing to control the private actor, the MS-13 case. And I'll tell you why. When, first of all, if you look at the transcript, if you look at what happened, first of all, this is an application indictment. This is what this case was about. This was not a trial at all. So in the application for indictment, we have the police report filed by the petitioner. We have the police report filed by the police, and you have the psychological report in this case. And with all that, they were unable to indict the persecutors in this case. And they dismissed the case. And in the dismissal document, if you look at the application for indictment document, there's not a single mention of it. It says—
Well, now, the counsel, our previous precedent is there's a difference between ineffectiveness and unwilling or unableness. I mean, there's a lot of crime in the United States, and we are ineffective at reducing it or mitigating it to the degree that we would like. And so if you put that to one side, where is the unwillingness or inability found? Because after the complaint was filed against Mr. Segaran, the gang member was arrested. An investigation was conducted. A search was conducted. Mr. Segaran was arrested and detained for 6 months. And he was only released when Mr. Ailman failed to show up in court to cooperate with the proposed prosecution. And even the fact of release was pursuant to a thorough and well-considered judicial decision. And I'm wondering, given this evidence, how that shows that the fact finder or the BIA reached a decision that no reasonable decision maker could possibly have reached. That's the question.
And so if you look at ineptitude, ineffectiveness of the police, and alone can be a basis for finding government acquiescence. It should be sufficient by itself. So the proposition we wish.
Well, but I thought our precedent says that ineffectiveness is not the legal standard, because there are all kinds of governments that try hard but still may be ineffective. And we have distinguished ineffectiveness from unwillingness or unableness.
But in this case, there was a completely breach of the government duty, because the petitioner, when the petitioner went to the police, first of all, it was the prosecutor, Norway in this case, he didn't spend 6 months in prison. He spent 4 months and 6 days in pre-detention. He was never in prison, so he was a pre-detention, first of all. And after that, the reason things didn't go well is because the family was being threatened. And the petitioner went to the police station. If you look at page 102 of the joint index, he went to the police and told the police the reason they are threatening me. They're telling me if I testify, they will kill me. And you know what the police officer said? Look at page 102 of the joint index. The police officer told him, just don't show up. Don't show up.
So there's a lot packed in this case here. There are things that the immigration judge did and did not do because it didn't need to do the manner in which it proceeded. Past persecution really wasn't one of the grounds. It really turned upon the consideration that the court and the BIA and the immigration judge turned upon the fact that they believe that the MS-3 matter was motivated by vengeance and retribution for not coming to testify. And yet the question here is one in which whether there's a familial relationship, it doesn't have to be the only evidence of it. And you could concede everything that they found here, at least in below. But at the same time, the question is whether or not there was a familiar relationship. And what you seem to be turning upon is it has to be intertwined. He didn't just go down there to confront this particular fellow at the police station for nothing. He went for his daughter. And then when the daughter was being threatened by this gang member to come back, and he received all those threats, even for the 5 days, it wasn't because they didn't like him. It was because of the daughter. And when you look at what the police did, the police didn't try to protect him. They protected the daughter from rape. They told him, says, well, if you wanna, you gotta testify or file this complaint against this MS-13 gang member. Now, it's only common sense that when you do that, you're going to have a problem. They weren't trying to protect him. And then even after he got his daughter back and the gang member comes to the house and then the gang member again threatens him, or the police response even at that point was, well, if at that point and before it was, well, if you want to protect it, then just don't show up. And the reason he didn't show up is because the government basically told him, if you don't want to, if you're facing these death threats, and if you don't want to do something about it, then you do it. Just don't show up at the trial and don't testify against them, then it will go away. But they're not going to drop these charges. They wouldn't let him drop the charges or do anything. So the bottom line is when we analyze this case right here, it is, I mean, we can accept everything that in the light they want to say, well, there's a motivation of vengeance and retribution for not filing a criminal complaint. All that can be true, but the question before us is whether there was, we can say that at least one of the factors here was a familiar relationship. It's very difficult not to determine that there's a familiar relationship here. And even when we get into the business of withholding or the asylum, and the question being of whether the police have done anything, they've done nothing in this record to protect this individual. They've done something to protect the daughter by putting her prosecuting the offending fellow here, the MS3 gang leader, and they consistently been doing that. But what they've not done is anything to help this man here. If anything, they've done the opposite, to require him, first of all, to file a criminal complaint against those individuals that he already knows are going to come after him. They in fact do. And when they do come against him, and he goes back and he says, I want to withdraw. I said, no, we're not going to let you withdraw it. Just don't show up. They told him that. So when he doesn't show up, that's when he gets in a big problem. All this relates very directly with the fact that he has a daughter. And that is the familiar relationship that at least appears to be at least one of the considerations. And Perez makes that clear. Doesn't need to be the whole case. This is not a weigh-in situation. It's a question of whether or not that's one of them. And how do you address that, at least from that perspective of this case?
And that's exactly right, Your Honor. That's our main argument. We agree that vengeance and retribution were part of it because he filed a police report. Absolutely no doubt about it. But the nexus, the definition of nexus, is one central reason for the persecution. It doesn't.
And that's the issue before us, is nexus. That's the key. Right. And I think that's when we differentiate, that's the issue before us, because the below that didn't really address the persecution point there. So it being the nexus here, and when we look at it, and if we go into what we've talked about extensively about the police want to protect him, they weren't protecting him. I don't see anything in this record that shows they're protecting him. You could come out and say they're protecting the daughter from this raping that's occurred by this bandit but I don't see anything here. They say they are protecting him beforehand to require him to even get his daughter back. If his daughter is a victim, why does he have to file a complaint to get his daughter back? He wants to get his daughter back, so he does file this complaint. And you know what the outcome is. It's predictably exactly what happens. The members show up for 5 days threatening he and his family to the point they cajole him to saying, you got to go down and withdraw this thing. He doesn't. I mean, it's an act of desperation. He goes down and tells him, I got to withdraw this. It's going to kill us. It's going to kill me and my daughter if we don't do this. And when their response is, just don't show up. Not that we're going to help you. Just don't show up. And you know the end result of not showing up is exactly what happens in this instance. Ultimately, he's released from it. When he's released, he goes right back to the same place and says, give me back that daughter, the one that I was raping, who's only 12 years old. That's something that I don't think the court adequately addressed this below, but I could be wrong. And I'd like to hear from the other side, too, when it comes up as to how that is not at least a factor when we look at the familiar relationship of why these things happen. It's his daughter. That's the key. It's his daughter. They didn't even care about this man one or other. From what I can see, it's all his daughter.
Mr. Benari, I had two questions with respect to that. When they arrest the gang member against whom the complaint was filed, isn't that protecting everyone? Both the father and the daughter. And second of all, before you even get to the question of a prohibited ground and a nexus, you have to ask the question, the antecedent question of whether there was persecution in the first place. The antecedent question is whether there was persecution. And then you get to the question of nexus and the question of whether the persecution was on account of a prohibited ground. But until you get to the point of persecution, you don't reach these other prohibited ground questions. And given all the evidence that the government made in this case, how do we get to the point that how do we get to the point that there's persecution here on inability and unwillingness to protect somebody when they actually arrest the person against whom the complaint is filed. That's trying, if you arrest the person against whom the complaint was filed, then you're trying to protect not only the daughter, but the person that filed a complaint, which is Mr. Aylmer. And here the efforts that the Salvadoran government made were extensive. And if this does not suffice as a reasonable decision, I can't imagine any case in which we would find that it was able, which we would find anything other than an unwillingness to protect. And the implications of the petitioner's view, it seems to me, are to fling the doors just way wide open. And I don't even see how we get beyond the question of persecution when the individual who filed the complaint is arrested by the government, detained by the government. His search was conducted by the government. How can that be an unreasonable finding of fact on the part of the decision maker? There's an antecedent question before you even get to nexus. And if you do get to nexus, arresting the person and detaining the person and wanting to try the person against who the complaint is filed, that can't be the nexus.
And Your Honor, first of all, persecution is not the in this case. The immigration found persecution in this case. The BIA found persecution in this case.
Wait. Counsel, sorry, it's Judge Harris. So the BIA says specifically, first they think there was no nexus. They say that. And I'm just assuming for purposes of argument now that's wrong. But they do go on. The BIA says specifically, and in the alternative, that they also haven't established that the authorities were unable or unwilling to protect them, given that the gang member who is the source of these threats was arrested, investigated, detained for 6 months. The respondent doesn't challenge any of these factual findings. We accept them as true. And based on that, no unwilling or unable to protect. So I mean, I understand what you're saying about they accepted some parts of the persecution showing, but they definitely did not accept the unwilling and unable to protect part. The BIA specifically said that showing hadn't been made here. So so that has to be wrong for you to prevail, right? We have to be able to say that that finding is not supported by substantial evidence.
That is correct. That is our argument. It's not supported by substantial evidence, Your Honor.
Did you make that argument in your brief? And I don't mean to be all picky, but I didn't even see that argument in your brief.
We did address the unable and unwillingness in our brief. We did.
Okay.
Yes, we did. Because that's the whole point. We believe that the government, yes, he was, first of all, Noe was not the subject of the investigation. His brother was. They were looking for his brother when they fell upon him. That's exactly what happened in this situation. And when that happened again, he was arrested temporarily, again, for 4 months and 6 days, and he was in pretrial detention. So he was actually never prosecuted for the crime of sexual abuse of a minor, never.
Well, I want to ask one question before we move on, and that is, I think we need to be clear. The BIA said that neither your client, Medrano, or the daughter established that the government was willing to help. But if you look at that IJ finding, that finding was never made as to Medrano. It was only made as to the daughter. And that's what's in the record. It's right there in the record that the finding on the government unwillingness exists only regarding the daughter. And I would ask you to look at that, because I think that's material here. It is, and maybe determinative. I like to hear the government's counsel deal with it. It's on when you look at the record pages 57 and 58. When you're looking at the IJ's finding, that's all he makes this finding on is the daughter. He does not talk about this defendant. But then the BIA somehow brings it out of whole cloth and includes him in it. It's not there. So I think that's a focal point that needs to be made.
I agree, Your Honor. I'm out of time.
All right. We thank you very much, sir, and you've reserved time for rebuttal, and we'd be happy to hear from you at that point. And in the meantime, let's hear from Ms. O'Donnell.
Thank you, Your Honor. Good morning. May it please the court, Margaret O'Donnell for the United States.
Ms. O'Donnell, would you address that point I just made at the end, and that is that insofar as the government's willingness to help or not help, the immigration judge only made that finding as to the daughter and not as to the defendant. And if you maintain otherwise, please tell me in the record where he did that.
I'm in the record right now because this was a new issue for me when you raised it.
Well, it's at the heart of what's going on. If he didn't make a finding here, and we're saying he did, and the BIA makes this finding, but there's nothing from the IJ. It's on pages 57, 58 in the record there, and he only makes it as to the daughter. He does not make it as to the petitioner here.
Okay. So
Ms. O'Donnell.
I'm sorry, Your Honor. I was trying to read where that is. I'm on page 50.
Why don't you just assume that Judge Wynn is right?
Let me just
Judge Wynn is
ask
right?
point.
Okay.
Yes, Judge Wynn is right.
I haven't encountered this, or it didn't come to my mind when I was writing my brief. I apologize.
But everything we're doing is on the finding. Whether you found it in your brief or not is right there in the record. And if he didn't make a finding insofar as defendant, and it's only as to the daughter, how in the world are we now gonna rely upon a finding that does not exist?
Ms. O'Donnell,
And counsel, can I layer on to that I would be open to the idea maybe that, well, the BIA made an independent finding based on this evidence that the respondent didn't challenge, but the BIA does frame its holding here as agreeing. It says agreeing twice. And it is correct that they're not agreeing with anything because the IJ didn't make this finding.
Right.
So do we need to send this back, get that squared away?
I don't know, Your Honor. I really don't. I think there's sufficient other arguments in here regarding nexus, et cetera, that may make that not necessary.
All right, but if you just assume for a minute that I think there is a nexus here under Cruz and for all the reasons Judge Wynn has been suggesting, just hypothetically, if I thought that, and so the only ground on which I could affirm would be this unwillingness to control or unwilling or unable to protect. And
that it's only made to the one petitioner.
Yeah, and I am quite convinced that the IJ only made that finding as to one. The BIA, it's a little ambiguous to me what the BIA thinks it's doing, but it does appear to believe that it is affirming the factual finding of an IJ that doesn't exist.
Right. And
so now what do I do?
If that is your only issue, then I would say that you should remand it.
Okay.
But I would not.
Ms. O'Donnell.
I don't know that I would concede at this
I
time.
totally understand. I am not reading you as conceding any part of that hypothetical. Thank you.
Ms. O'Donnell, why isn't the answer simply that you have a petitioner here who filed a complaint against a gang member, and the gang member was thereafter arrested. And as I mentioned earlier, I'll repeat it because it's important, an investigation was conducted, a search was conducted. The man against whom the complaint was filed was arrested and detained for 6 months. And he was only released when he refused to cooperate with the prosecution. Now, how can that not be protecting him when the Salvadoran authorities arrest and search and prepare to prosecute the very person against whom he filed the complaint? That goes to protecting him. If you
Your
file
Honor,
a complaint against somebody, it's got to, and the government takes action against the person you file a complaint about. How does that show unwillingness or unableness?
Your Honor, I completely agree with you on this. And not only that, but the record from the court in El Salvador is so detailed. I was surprised at how detailed it was. But
well, let me ask you, I want you to answer that question, but I want to do it in the context of what really happened. They didn't just go and arrest him and keep him there. They only did it after they insisted that he file a complaint. And his purpose of doing so was to get his daughter back. So then they go and get him, and then these gang members, which you would think just having him locked up is protecting, but this man is part of the MS-13 gang. That gang comes after them for 5 days. And whether he's in jail or not, he certainly has opportunities to be able to direct certain actions. And so he's there. This man is threatened for 5 days continuously. And to say it in a vacuum as though we're in the United States of America where police goes in and sees someone raping a 12-year-old, you don't need someone to file a complaint to prosecute that person. A police can do that. Anybody, we wouldn't even ask the father to come down and file a complaint on it to do it, because they saw this man raping a minor, and they arrested him for it. But they could arrest him and he could be prosecuted on that alone. But they insisted the father do it. So then the father gets his daughter back. He's then threatened, and that's the prosecution, if you want it. Threatened to kill is real prosecution. They threatened to kill him. And as a result that he goes back, he tries to withdraw it. They won't let him do it. They're not trying to protect him. He's coming down to protect himself and his family. They're not going to let him withdraw it. So then here's the part that I don't believe in the United States of America anybody would say this is okay, but if you leave this fact out, you wouldn't know it. They tell him don't show up. That's what you do. Now, when the government tells you don't show up, that's the way you can protect yourself. That's not the government protecting you, and it has to be imaginative to even think they are protecting this man here. They are not protecting. That's what IJA made the finding. But now on the appellate level, even if we wanted to make the finding, we'd have to go off the record and then look at these facts in a vacuum and leave out those additional things. They made him file that complaint to get his daughter back. They did absolutely nothing when he tried to withdraw it, and told him instead affirmatively, don't show up. And we then now say, well, they're protecting him. But the IJ never made such a finding. That's the reason he never made it. He knows it didn't happen. If they're doing anything, maybe they're protecting the daughter. And that's another case. But that's not the case here.
Ms. O'Donnell, it's a perfectly reasonable step to ask someone to file a complaint. You don't want, in certain situations, the police to be running around all over the country and just arresting people and prosecuting people without any sort of basis. There are all kinds of situations in which domestic abuse is one. You don't issue restraining orders against the abuser unless a complaint is filed. There is simply nothing irregular or wrong about asking someone to file a complaint and for the police to have some grounds to withstand a legal challenge on which they arrested somebody. We don't want police in any country taking groundless actions. And that's so filing a complaint was quite a reasonable step for any judicial process to insist upon.
I agree with you
I
wholeheartedly.
want you to answer that, but I want to add, at least make sure we do it in this vacuum. And that is, first of all, this is not them asking him to file a complaint. They said he wouldn't get his daughter back unless he did. And then the second point is, you don't have to run around the country. They walked in and saw this man raping the daughter. This is not an instance where there's accusations all over the place that he's raping the daughter. They saw him raping. They saw the crime. The police are the witnesses to the very crime here. So this business of they asked him to file a complaint, that's not exactly what the record says. He came to get his daughter. They says, you won't get your daughter unless you file this complaint. That's a different situation than where you have someone who's been raped and then you go and say, well, here's your daughter, and now we want you to file a complaint. Totally different.
I see your point, but I feel Judge Wilkinson's point is stronger. One, we don't know what the laws are in El Salvador. But if I'm a police officer with a 13-year-old child that was being raped, and some man showed up to pick her up claiming she was his daughter, I'd want to know that he was invested. Because this young lady went to live with that young man in his parents' home 10 or 14 days prior to the arrest.
I'm sorry, is the government's position that when parents come to prisons or jails, I guess, to pick up their children who have been victims of violent crimes before they get them back, the jail officials are going to run a check on how invested they are as parents? I don't understand what you're saying.
That's not my point. My point is, no, when this little girl disappeared from her home 10 or 14 days prior, depending on the dates, there is no testimony of any efforts to bring that child back home prior.
So that is what you're saying. Like, this father shouldn't have gotten his daughter back because he was not doing what? Like,
conclusion, because there's just no evidence that he did.
How is this even a question, though? Like, when parents come,
there's no evidence that he did anything.
Why should there have to be any evidence?
Evidence of him trying to get the daughter back. In other words, he's never imposed himself in any way as an obstruction to that relationship, as far as we know from the record. So why? It's not until he writes that complaint, when he completes that complaint, that is when the gang focuses on him.
I think I see what you're saying, counsel, but I don't see how that helps you at all on the nexus inquiry, because now you're saying before he can get his daughter back, he has to really prove up this is an important relationship to him. He's trying to protect that girl. That's exactly what you're saying.
There's nothing in the record about El Salvadoran law. We don't know whether or not, can a police officer allow someone to withdraw a complaint? I don't know. I'm not an expert in that area.
Well, do we know enough about the law that if the record shows the Salvadoran government said they caught him in delicto flagrante, they caught them in the act, they saw him, and we don't know enough. I don't know a country on planet Earth that if the authorities catch you in the act, if you're shooting someone and murdering someone, why do you have to go to the victim's family to get a complaint? If you're raping a minor child and in front of the police and the government in delicto flagrante, what in the world says you got to have the police, the father, to file a complaint under any law on planet Earth?
I don't know, Your Honor.
Well,
I don't know, but the father
never heard of one.
And then he chose not to attend the hearing. Not just him, the entire family did not attend, including, now, keep in mind, the girl also filed a complaint, but she was not threatened, thankfully. But the entire family did not show for that hearing. The investigation
weren't they told that was the way in which they could essentially avoid this being killed?
Avoid the threats from the gangs, yes.
Is the way you can not get killed is don't come to the trial. And you put it in a language of they chose. Who chooses? In other words, they chose life over death by not going to the trial.
I understand your point.
How much of this was brought up before the fact finder? It seems to me we're sort of weaving a narrative of our own up here. But you know, the IJ, the PIA has been charged with the Attorney General of enforcing this statute, and the IJ has been charged with hearing the facts on this. And what I hear is an appellate narrative that is making suppositions and substituting us as a finder of fact. Isn't that what's
Well, let's go back to the record then and to the finding where the ILJ didn't make the finding. If you don't want to weave some facts, don't weave that fact. He did make a finding that this fellow had that from the perspective of the judge. So there we are.
Ms. O'Donnell, do you have something you'd wish to say?
I don't even know how to respond to that.
How you respond to it is by saying that in the steps that they took to prosecute Mr. Segaran, that they are trying to remove the problem root and branch, that they're trying to take care of the entire problem, which will resolve, which will both protect the daughter and will protect Mr. Aylmer. Now, how that could possibly qualify as persecution, the asylum statutes were primarily directed at state persecution. We don't have that here, no state persecution. Any persecution must come through inability or unwillingness, and that's different from ineffectiveness. But how can it be unable or unwilling to address a problem when they arrest the one who is the source of the problem and are bent on prosecuting him according to their normal procedural principles? How does that translate into an unwillingness or an inability to protect anyone when if Mr. Segaran is detained and convicted, he's detained substantially before the trial, there's a good chance with Mr. Aylman's cooperation that he would be convicted. And that would remove the source of the problem, and it would protect not only Mr. Aylman's daughter, but Mr. Aylman himself. That doesn't translate into inability or unwillingness.
I agree 100%.
And you should agree, because that's a good argument, but none of that is in the findings insofar as what's here. If you want to speak of weaving some facts, that's weaving facts that are not been made here. There's no real. Do you maintain that there's a direct findings insofar as persecution in this case?
Yes, and not only that, but the record has the court's translation as to what they did, the forensic evidence they did on her, the medical evidence they performed on the young lady.
The record, Ms. O'Donnell, the record contains all of this. We don't need to embellish the record or create. The record contains that this individual, this gang member, was arrested, that he was investigated, that the search was conducted, that there was detention, that the police refused to didn't want to dismiss the complaint because they wanted to prosecute, and the case was actually set up with a court date. And unfortunately, Mr. Aylman decline to appear. But all of the steps they took are in the record. And just applying some common sense, there is absolutely no evidence that no reason that can be gleaned from all these steps that Salvadoran authorities were unwilling or unable to protect this person. They didn't just let him go. They didn't just turn their back. They didn't just turn a blind eye.
That's right.
They went after him.
Why did they go? Why did they go after him?
For the rape of a minor?
And once they got him, and did they not personally witness that rape?
Yes.
Why did they need to go after? Do they need this complaint to be able to arrest this individual for something they saw? And by the way, when did they arrest him?
That night. Was it the 4th of October?
Did they arrest him after they saw him in this act? They took him into custody then?
They took the two of them into custody, yes.
So did they have him in custody when the father came to get his daughter?
I assume they did.
What do you mean you assume they did? You think they let him go?
No, I don't think they let him go. There's nothing.
I thought you just told me they took him into custody along with the daughter. You think they would keep the daughter and let him go?
I'm sorry. I don't even understand that. No,
Well, let's not confuse ourselves, and I want to make sure we step back so I understand. We get the facts right. They go in, and they just, of course, they're there for something else, and they discover this individual, this gang member, in the act of raping this minor child. And you say they took both of them into custody. Is that right?
They took them both down to the station and into custody.
So they have him in custody for raping this minor child. And then the father comes to get his daughter. He's not coming about the rape. He's coming to get his daughter, who's being held by the police. And they won't let him take her until he files the complaint. That correct?
That's my understanding of the record, yes.
Where does he need protection from someone they already have in custody and they have already witnessed has raped this man's daughter? What is the protection? And have they heard any threats against him, or are they doing anything to protect him?
By him, you mean the petitioner? I just want to be clear.
Yes.
Okay. At this point, why does he need protection? The young man is locked up. And as long as the young man stays locked up, everything's fine. Until he's approached by the leader of the gang, who doesn't technically, according to his own testimony, didn't make a death threat, but just said it would be to your detriment. That was the translation. So yes, a finding of persecution was made based on the death threat, is a understanding of it. But I don't understand the issue of protection. The young man is locked up. It's only when the young man is provisionally acquitted and released that he returns to Aliman's home to seek out the daughter. But
all right, thank you, Ms.
Thank you.
Mr. Canary, we'd be pleased to hear from you in rebuttal.
Yes, Your Honor, what I want to make it clear is the source of the problem is not only Norway. The source of the problem here is MS-13 in general and Norway. That's the point. MS-13 is bigger than Norway. So when you say protection and the steps the courts have taken, it's just not sufficient, because when the petitioner went to the police and told police the threat he was facing, it was not from Norway, it's from the other MS-13 members. And the police knew about that and did not provide any protection about it. And instead told him, don't show up, don't show up. You said a minute ago that the family declined to participate. They didn't decline to participate. It was not their choice. They were threatened not to participate. First of all, after he filed the police report, these people were in front of his house for 5 days straight, brandishing arms and weapons at him, and every turn going to work and coming back, he was being threatened. And they were telling him, if you and your daughter do not go and take the police report back, you will suffer dire consequences. That is the translation. So the police knew about it, but no protection was provided. So Noe only being in detention does not provide.
I can't hear you at this point, Mr. Canary. Would you?
Neither can I.
Oh, I'm sorry. I'm sorry. Can you hear me now? Okay.
Yes.
So it does.
Mr.
So,
Canary, what do you do with the fact that the police actually killed Il Prisionero, and he was the first gang member to threaten Mr. Ailman, and as I understand it, the police killed him. That would seem to me to indicate a willingness to protect Mr. Ailman when the person who threatened him, the first gang member who threatened him, was killed by the police. How do you deal with that fact?
very good, Your Honor. Where a government contains official that will be complicit in torture, and that government on the whole is admittedly incapable of actually preventing that torture. The fact is,
I'm talking about Mr. El Prisionero.
Right.
And the fact that he had threatened Mr. Ailman and he was killed.
That is correct. He was killed, but what happened after he was killed? Noe became his replacement. Noe became.
No, but he was the very first one to threaten Mr. Ailman, and your position is that there was an unwillingness to protect him, despite the fact that they actually killed the first person who threatened him. How does that translate into unwillingness or inability?
But that his killing has nothing to do with the prosecution of the petitioner. And that happened when he was on his way to the United States. That was related. We don't know what happened in that case as to what happened. We have no clue. We know it happened, but it's completely unrelated to the petitioner's case. And when after that happened, Noe, the main persecutor, the main person became his replacement and became the gang leader at that point. So there's no protection for the respondent, for the petitioner at all, none whatsoever. And there's no protection for the petitioner because they had to move from Usulután to La Unión, and still they were not safe. That is the whole reason why they had to come to the United States, because if they were safe, Judge Wilkinson, they wouldn't be coming to the United States. Nobody would leave their homeland just for the hell of it. If they were protected, they would not have left their country. And you did not need the cooperation of the petitioner. You don't need the cooperation of the petitioner's wife at all. You don't need it because you have enough. You have the police caller. You have the complaint filed by the petitioner. You have the psychological report, but you understand the indictment was dismissed. How can that be? How can you dismiss an indictment against this person given all the evidence you just cited? It's impossible. You cannot protect the petitioner with the indictment, with all the facts you cited, Your Honor. You can't. I'm out of time, Your Honor.
Well, you said that I thought Mr. Ailman acknowledged that had he appeared in court, Mr. Segaran would not have been released.
But they don't need him. They did not need him at all. They knew he was being threatened. They didn't need him. They have the police were the witnesses. They have the psychological report. They have the police report from the daughter. And the daughter told the police that she was assaulted by Noe. That is in the record. She was assaulted, not only raped, but she was assaulted. How can you dismiss that case? How can you say that the Salvadoran government is trying to protect the petitioner? It's impossible, Your Honor. They can't. They were unable and unwilling. Guess what? An applicant ability to file a police report may suggest that the police were willing to protect him, but it says little about their ability to do so. Completely different. Willingness and ability. It is about the success of the endeavor. It's not about what the laws are in the books. It's not about the lip syncing. It's not about the empty promises and empty token. It's what you actually do. This case should never been dismissed against Noe. Never. In any country.
Mr. Canary, thank you very much for your
Sure.
argument. Ms. O'Donnell, thank you very much for your argument. And I'm sorry that we are unable to come down and shake your hands, which is our traditional circuit custom. But I hope the day will come when we are able to come down and greet and thank you in person.
Thank you.
With that, I would like to
The judges of the United States Court of Appeals for the Fourth Circuit.
All right, Mr. Hannah, whenever you're ready, we'd be pleased to hear from you.
Yes, sir. Good morning. May it please the court. My name is Steve Hannah, and I represent Mr. Richard McCormick in this matter on appeal from the district court, and I was appointed by this court. Let me preface my comments, if the court will allow me, and per the government's brief on the single-tary issues, I think for the interest of the economy, I think the government is essentially in agreement with the defense in that those matters would go back at a minimum. Those matters would go back for resentencing. So again, pursuant to the single-tary decision by this court this calendar year, actually. But that said, the framework of this case, as you see, is very limited. I suggest to the court very simple. What you have before you in the joint appendix is the plea transcript is only 8 pages. The sentencing transcript is 5 pages. The plea hearing itself took 9 minutes. The sentencing hearing itself took 5 minutes. So it was, the entire case, I should say, was brief.
Do you wish to withdraw the plea? Does your client wish to withdraw his plea? I mean, sometimes the plea can be a pretty good deal.
Understood, Judge. I have.
Because I mean, what are we going through all this for if you don't want to withdraw your plea?
Your Honor, respectfully, I was instructed by, you may recall, I was instructed by the court to address these issues.
Well, I understand that, but you obviously had some conversations with your client, the individual you represent, and I'm wondering whether this gentleman wishes to withdraw his plea.
I have not received that information from my client, Judge, Your Honor.
Well, then
I agree with Judge Wilkerson. That's a very critical issue in this case. I think on this part.
Yes, sir. I have not received that from my client, and therefore I did not raise it myself on my initial brief. I just simply addressed the issues that the court ordered me to address.
I know, but we have to, I understand that, but on the other hand, we can't be issuing advisory opinions up here on appeal about plea hearings and this and that.
Yes, sir.
There's a lot of people might say, well, I want to take this up to the Court of Appeals and find out whether the plea hearing and the sentencing was fair, and then I'll decide.
Yes, sir.
I want to withdraw my plea. And if we follow that road, we could be issuing a lot of advisory opinions that you're nowhere.
You're preaching to the choir, Your Honor. Again, which is why I have not received that those marching orders, so to speak, from my client, and therefore I did not raise that in my initial brief. So the answer to your question is no. Again, what I submitted to the supplemental brief was only, respectfully, response to the direction and order of the court. So
Can you just remind me what was in your original brief before our order?
it was pertaining to the sentencing issues.
It was just sentencing, okay.
Yes, ma'am, and it was an Anders.
Okay, yeah, but it was only on the sentencing side, okay.
Yes, ma'am.
But you're challenging the plea hearing as well.
Well, yes, sir, only pursuant to the court's order to do so.
Okay, but you are.
Well, yes, sir.
I mean, if you upend the plea hearing, you've upended the sentencing hearing.
Understood, Judge. So I appreciate I understand the court's inquiry, and so when I got the order from the court to address these issues, which was put forth in my supplemental brief, again, obeying the order of the court, and I discussed this, of course, with the government recently.
Let me see if this can't be a way you can deal with this. Maybe we can move forward. And that is, we all know in the Rule 11 context, plain error inquiry means that you must demonstrate a reasonable probability, but for the error, you would not have pled guilty.
Yes, sir.
So given the fact of where you are now, can we just assume you're not pursuing that argument?
Well,
I mean, if you are, then the ultimate result is you might get something you don't want.
The client was not requesting it, and I was not requesting it in my original brief. Again, I find myself in an odd situation, Your Honor. Again, I only submitted this pursuant to the order of the court.
But you represent your client.
Yes, sir.
And notwithstanding the orders of the court, you've complied with that order. I'm talking about at this point.
Yes, sir.
It would seem prudent under these circumstances, you represent your client.
Yes, sir.
And that is the important thing here. And unless you as the lawyer, even consulting your client, you got advice you're going to give him. And I can't imagine that advice is going to be anything other than you would think was favorable for him.
Yes, sir.
And the question here is, in light of what you said, you don't have to pursue that argument, is what I'm saying at this point.
I would rather not pursue the argument, Your Honor. And if the court would relieve me of the responsibility of pursuing that argument, that would be fine with me. Again, I did not pursue that argument in my original brief. I was not given instruction to pursue that argument.
Well, Judge Wynn is correct that an important ingredient in all of this is whether there's a reasonable probability that he would not have pled guilty. And if he's going to continue to plead, he's not going to say, I wish to withdraw my plea. That kind of undercuts any reasonable probability that he would not have pled guilty. He still wants to plead guilty.
Yeah, understood, Your Honor. We are all on the same page now. I do agree. I think the singularity issues exist, which have, as far as the resentencing, and I think, quite frankly, that's a fairly quick, or I should say, that I can be dotted in a fairly efficient manner. But the issue as far as the plea itself, I agree with Your Honor, again, which is why, respectfully, I never raised it initially, nor was I instructed to. And so when I find myself in a unique situation where I got the order of the court to raise these interesting issues, and
will raise those interesting issues, but it would not have precluded your raising the interesting issues if one was to lay the proper predicate. Maybe you just assume we just can't assume that he would wish to withdraw his plea, because that is just taking that's taking liberties with him. I mean, he's the one that decides whether he wants to withdraw the plea or not, and that's an important factual predicate for looking at any of this.
Yes, sir. I had no information on that subject, so I was not given my marching orders on that subject by the client, and therefore, as I said, and I realize I'm being repetitive, so please bear with me. Again, I never.
What you've been very clear about is he hasn't asked you to vacate this plea. You've been very clear on that.
Yes,
and
sir.
If he hasn't asked you to vacate this plea, then that kind of answers our question.
Yes, sir. Yes, sir.
What about the government's argument on the asset forfeiture? Maybe that's something as part of the sentence that might be something interesting to talk about.
Yes, sir. Well, again, as far as the signatory issues, which is raised in the government's corrected brief, and I think we're in agreement with that. But the rule, as far as the forfeiture and whatnot, and I realize it's a type of sanction, but the rule is very clear that these things have to be discussed with the defendant in open court. And with all due respect to the trial court, I'm trying to put this as gingerly as I can, mistakes were made. It seemed to be rather rushed. And when it goes back, I suggest for a resentencing on the signatory issues, then this issue would be on top of that, or to say, in addition to that. So that's,
Well, I'm still hung up on the withdrawal of the plea question, which to me is fundamental to all of the issues, sentencing and both with respect to the plea hearing and the sentencing hearing. And if there's no representation at all, and then why shouldn't we just dismiss the appeal as asking us for an advisory opinion, because there's been no representation to us that the petitioner has requested any kind of relief.
Judge, again, respectfully, you get no argument from me on that, which, I know I sound like a broken record, but my brief was only a response to the court's order to brief the subject. But yes, you and I, Judge, respectfully, we're on the same page. I do not have that request from my client, nor do I have that from the trial counsel, who I've been in contact with when I inherited the case.
All right. Thank you. Are there further questions?
I have none.
No.
Thank you. We'll be prepared then to hear from Mr. Rogers. Mr. Rogers, why don't you need to.
Thank you, Your Honor.
There you go.
Your Honor, obviously the central issue here is whether the defendant wants to withdraw his plea. I contacted appellate counsel this week and asked him what his position was on that. My presumption had been up to that point that the defendant wanted to pursue this, but I wanted to make sure. So I did call this week and I asked, because our office has had no indication from anyone that the defendant wanted to withdraw his plea. And I heard the same thing that opposing counsel just shared here. So I do believe that this really resolves the case and leaves nothing more than.
So the point is there's no representation before us that the petitioner even wishes to withdraw the plea.
And there has been none to us either.
Yeah.
In light of that, the appropriate disposition would seem to me to be to dismiss the case and affirm the district court and only remand for the purposes of the Singletary issue.
All right. Do you have anything to say about the Singletary issue? We have to remand on the Singletary, don't we?
We acknowledge that the district court erred when it included non-mandatory conditions of supervised release in the written judgment, and that it didn't pronounce at sentencing. And so we have no argument to make that there was somehow a way around that mistake by the district court.
All right, thank you. Are there any questions of Mr. Rogers?
I have none.
All right, Mr. Hanna, do you have anything further you wish to say?
Your Honor, I don't. Again, I appreciate you kind of putting up with me in this matter. I realize it's a kind of a unique situation, which I want, Mr. Hanna, I want to say that I don't fault you at all, because I think you were proceeding in complete good faith and the highest standards of professionalism to take on the case and to address the questions that were before us. And so I don't, this doesn't imply any criticism of you, and I wouldn't want you to go away thinking that we did. Thank you, Judge. I appreciate that.
Okay. All right. We will thank you, and then we will move directly into our final case.
Thank you, Your Honor.
Thank you. Thank you, sir.
see, Mr. Coulter, you're the first up, so whenever you're ready, we'd be happy to hear from you.
Good morning, Your Honor, Your Honors. May it please the court, my name is Scott Coulter and I represent the appellant Jabral Smith. With the court's permission, it would be my plan to begin discussing the trial court's failure to instruct the jury on the lesser included offense of simple possession of heroin. Pursuant to Keebles versus United States, defendants entitled to an instruction on the lesser included offense if the evidence would permit a jury to rationally find him guilty of the lesser offense and acquit him on the greater. The district court must give an instruction on simple possession when proof of distribution is sufficiently in dispute to allow the jury to convict the defendant on simple possession. That was in the United States versus Baker, 1993 Fourth Circuit case.
So we can all agree on the general law that a defendant is entitled to an instruction on a lesser included offense if it would permit the jury to find him guilty of a lesser offense and acquit him of the greater one. But what that means in drug possession cases has taken on a whole different light. We've got cases all over the board on this, or at least going in different directions on it. And I don't know how we fix it, but we've got a number of cases, Levy, Baker, and Wright would be just three that I can think of right from the beginning. So discuss, if you will, the state of the law, at least in our circuit, on when a jury would be required or the judge required to submit a lesser included offense in drug cases. And I forget, but I don't know why there's such a differentiation in drug cases than others, other than, maybe there's a policy, but maybe I'll get back to that. But if you will, in the context here, because I think that's the hurdle, or at least the main challenge we deal with in this particular case is, should the judge have given that lesser included offense to the jury?
Your Honor, it was somewhat confusing when I went through it initially at the trial court level, but it's fairly well laid out in a unpublished opinion that United States versus Hall, 397 Federal Appendix 860, Fourth Circuit case in 2010.
When you say fairly well laid out, are you saying it explained the other cases, or it itself made something, because it's not binding as an unpublished opinion?
Correct. I think
So tell me, lay it out for us what the state of the law is, and because there are some tensions here and there, and why it is your particular case, this case, should be sent back on the lesser included offense.
Yes, Your Honor. The beginning in 1981, there's a case, United States versus Senning, where the defendant asked for a lesser included offense, where he was charged with possessing 15 tons of marijuana in a shipping trawler. In that case, he was denied, and the district court was affirmed because the amount involved was too large for a rational dispute.
That underscores the whole thing. We have given district courts a large discretion on whether to issue instructions in general, but a lesser included instruction in particular. And there's a reason for that, because instructions have to rest upon a bed of evidence. And the person in the best position to understand the strength of the evidence is the trial judge, who's actually sitting there and listening to it. And it seems to me, if there is any kind of issue on which we would accord the district judge some respect, it would be on an instructional issue with a lesser included. And it's an abuse of discretion standard for a very good reason. And here, there was expert testimony which indicated that the amount in issue was far in excess than the amount needed for simple possession. I think it said it might be theoretically possible for someone to possess this quantity of drugs as a mere possession, as a matter of mere possession. But it said, well, it would practically kill you if you did. And when you combine that with the text messages here and the firearm and the fact that Smith's DNA was consistent with the DNA on the firearms, and you combine that with the drug amount, how can it be an abuse of discretion for a district court not to give this kind of instruction? And particularly, even when there's no lesser included offense instruction, the prosecution undertakes a real risk because it's still got to approve the higher offense. A lot of times the prosecutor may have overcharged, and if there's no lesser included instruction, the prosecutor may end up with all or nothing. And
Your Honor,
maybe nothing. And but what I'm saying is this is a classic trial court call. We can't be redoing trials and the district court's assessment of the strength of the evidence here, particularly when there's sufficient evidence to indicate that this individual was in possession of a far greater amount than was needed for his personal use. And that's not to even mention the text messages and the firearm.
Yes, Your Honor. However, the Fourth Circuit has reversed the trial court on this issue on at least two occasions. In United States versus Levy, defendant possessed 0.8 grams of 100% pure cocaine and 4.75 grams of 95% pure cocaine worth $14,000. And the Fourth Circuit indicated that the court was required to give an instruction in United States.
That's why I really think is important. I agree. We respect the trial judge and what the trial judge has done. What I'm concerned about is what we've said to the trial judges in doing it. And you point out the Levy case, and then there are cases that deal specifically and seem to indicate quantity alone may be enough, and then come back and say, no, that's not enough. You've got the Baker case, in which there is some division there. The court revisited that issue, and in that case found that severe cocaine addiction could give rise to the instruction. And then you've got even the Wright case that comes up and that deals with it. Again, you got a quantity versus situation, but quantity is not the only one. And you've had cases in which you've had higher doses. I mean, Smith had only 20 to 30 doses of case and said it was possible. This amount could be for personal use. This same expert says it's possible. That could be personal use. And he's given his testimony. So the question, and that's why I'm saying in drug cases, this thing is not so cut and dry. It is, if we go back and look at our precedent on it, some of it which looks like there's dictum and footnotes and Levy, there's all kinds of stuff. And then you got the Baker case quoting the D.C. Circuit Court case. And that case says that there's any evidence fairly tending to bear upon the lesser included offense, however weak that evidence may be. We quoted that language in Baker. And, if we're going to be consistent in the way we apply law, and whether we go one way or the other, we on the appellate court, I'm not talking about the trial court and his discretion and giving him respect. Oh, well, and good. But respect on what? Respect for what we are saying if it's not said in a consistent way. So the state of the law on this thing is not so solid or so consistent as to say, well, this is exactly what it is. We can cherry pick cases and say, oh, well, because of all of the quantity in it, it was a lot. But that's not the state of the law at all. I mean, there have been cases where quantity is not definitely different. So that's what I'm going at and saying, where are we in the state of our law here in terms of making this determination of what it is the trial judge should do? That's what we ought to do to trial judges. We ought to give them something that is solid and consistent instead of cases bouncing all over the place. And from time to time, we need to take it en banc to give that ultimate consideration so that we don't have these cases that are in conflict, because judges do have different opinions. And that is acknowledged, that we have different opinions. And if we get a chance to write a case, maybe it goes one way and the other side goes the other way. But ultimately, we as a court need a uniform way in which to deal with these kind of cases. And drug cases has really been at the forefront of a lot of these issues. So that's where I was going with this in terms of tell us the state of the law here and how does it fit within those cases.
I would submit that the best statement comes from United States versus Levy, where the court indicates if a question of distribution is capable of two answers, the lesser included offense instruction is appropriate.
Yeah, but there have been an equal number of cases where we've said that these cases depend on their facts, that district courts with respect to instructional issues are best capable of assessing facts. And you can't, all of these evidentiary questions, you can't script them all on appeal. You can't, the factual variations and the different circumstances and the weight of the different testimony, you can't just, this is part of the problem I have, is that we try to take over too much of a trial judge's function when that depends crucially on the trial judge's eyes and ears, and you cannot script it. You cannot find a particular set of criteria, this, that, and this. We all know what the set of criteria are. It's the amount, it's surrounding circumstances, the presence of firearms, any kind of text messages. But, the cases vary from one set of facts to another. And it just is one of the difficulties with appellate judging is we continue to want to make ourselves into fact finders or trial conductors, and you cannot script that.
I want to express my agreement with Judge Wilkerson on that so it's not misunderstood. I agree with Judge Wilkerson. The problem we have as appellate judges is we sit in 3-judge panels and we issue different opinions. That's the issue I want to address here. I agree with him. If you had one panel that gave all the answers and it was the same on down and the judge didn't deal with it, that's it. I'm not addressing the trial judge here. What I'm saying is the same concern. We need to give the trial judge consistent information. And these cases, whether there's a bunch of them that go this way or a bunch go that way, you can't just give the trial judge a chance to cherry pick them. You need to give consistent information on this.
Can I ask a question, which I think goes to sort of what we're talking about? What standard do you think the district court should have applied in answering this question? Should there be an instruction?
Your Honor.
And what did you argue for in your brief? I thought your brief was saying that what the district court should have done, following Hall, basically, was given instruction on simple possession if the proof of distribution is sufficiently in dispute to allow a jury to convict on simple possession. Is that the standard that you would have us use?
Yes, Your Honor. And
the Hall standard, okay.
And Your Honor, Special Agent Razik, the government's expert, indicated that 3.32 grams of heroin could be a user amount. He also indicated that the fact that the heroin was packaged in a single bag could tend to show a user amount. That suggests that there are two possible answers. Now, Special Agent Razik opined that it was a distribution amount, but that doesn't mean that there aren't two possible answers to that question. And when that occurs...
I just want to nail this down. because I totally agree with both of my colleagues. There's a lot going on in this case, and we've said a bunch of different things. But for purposes of this case, as I understand it, and I will ask your colleague this as well, both of you are arguing apply the sufficiently in dispute standard, and then you come out different ways under that standard. And that's what we're here to talk about.
Again, I go back to the quote in United States Levy: if the question of distribution is capable of two answers, the lesser included offense is appropriate. And I'm out of time, Your Honor.
Well, it's not, those are not the two answers we're talking about. The question is whether it's sufficiently in dispute. You've got things like, the expert testimony and other things, but that's a judgment call as to whether something's sufficiently in dispute. It cannot be other than a judgment call, which is why I'm so reluctant to try to fine tune it and write a set of universally applicable principles which break down into the practicality of a trial proceeding. At any rate, we need to hear both sides of this. So, Mr. Alsop, let's hear from you.
Good morning, Your Honors. I believe this may it please the court. I think the government would agree with Judge Nguyen that the law is somewhat unsettled given what this court's various panel opinions look like. We would also agree with you, Judge Wilkinson, that there's a heavy amount of discretion afforded any trial judge dealing with a range of factual issues that cannot be scripted. If I could answer Judge Nguyen's question first as to the state of the law. Essentially, we took the tack in our brief that it would be easier for the defendant to meet his burden of saying the lesser included should have been instructed in this case by using Baker. And Baker's holding, as the court has already discussed, is sufficiently in dispute to allow a jury to consistently find the defendant innocent of the greater and guilty of the lesser offense. Baker relies very heavily on the DC Circuit case Gibbs. Gibbs' facts are a little different. There were a number of individuals in a car, a firearm or two, and 15.5 grams of crack, and that's it. And in Gibbs, although we agree with your assessment, Your Honor, in Gibbs, that there's some pretty, light language saying, well, if there's a reasonable dispute here, and as Mr. Coulter said, it could be decided in two ways, then the judge should give that instruction. In our view, the consistently in dispute language in Baker, we don't believe, we look at Baker as like a threshold analysis, sort of like a gatekeeping analysis where.
Well, why don't you go over the evidence here that led the district court to regard this as a distribution case? Go over the particulars.
The particulars were this, and the district court went on for about this in 4 pages between the joint appendix in 833 to 837. But the trial evidence was essentially this. Corporal Buchanan had talked to a number of heroin users in his career and come across them, knew what they used for user paraphernalia. He did not find any of those things in the car, period. He also made an assessment.
Is that what you were saying? Is that what he meant when he said that drugs weren't packaged in bundles for individual sale?
Corporal Buchanan did say that, but he also said it was a large bag, as I recall.
But he did say that. And then there were no scales or weighing paraphernalia on him, and this defendant didn't have any cash on him. That's correct, Your Honor. So that, in addition to in terms of simple possession, the fact that there was 20 to 30 doses, and even the experts said that could be for personal use. So that's the question that we now come to, and I think Judge Wilkinson and I are there, and the divide may happen there. What I want to be clear on is we're not divided on the law. that the law is what it is. If we interpret it differently, that's one thing. But it's but at this point, if Baker is the guiding principle that the parties agree, and I don't disagree with that at all. But and then we move to the consider this. Then the question is this evidence that we just talked about would be sufficient to require the judge to submit it to a lesser included offense? I mean, you can have all the other stuff.
In detail, I want you to canvass that evidence, and including the fact that the expert didn't say, "Oh yeah, this would be fine for personal use." So you'd kill yourself if you tried to use that amount. Go over the evidence here that led the district court to decline to give the instruction.
So yes, Your Honor, and I'll do that. And so my answer to your question, Judge Nguyen, is no. Under the evidence we have, which is essentially this: Corporal Buchanan didn't find any user paraphernalia in the car. Corporal Lowe, who has also come across heroin addicts in his career, did not find any user paraphernalia in the car, very specific to heroin users: needles, tubes, tourniquets, belts.
I'm so sorry. I know you want to get through your evidence, but this goes to just almost like the one kind of conceptual question I have about this case. In your brief, as I understand your position, you were sort of saying, go with sufficiently in dispute. We're not going to ask you to apply the suggestion coming out of Wright that there needs to be affirmative evidence of personal use to get the instruction. We're not arguing that. We're just saying sufficiently in dispute. But you are saying that when we consider whether the distribution evidence or the case for distribution is sufficiently in dispute, one of the factors we should look at then is whether there's evidence of personal use, because if there's not, that makes the distribution case stronger? Yes,
and I would say that's supported even in Baker, because Baker relies on Gibbs.
No, I know. But do you see that I do understand what you're saying. I worry that that's sort of bringing this kind of Wright test, the alleged Wright test, that you need the affirmative evidence of personal use, just kind of right back in through the back door.
And I don't think we're trying to intend to do that. If I could answer that question shortly, the district court, consistent with what the court did in Gibbs, is the district court looked at, I think the district court's terms were the totality of facts. And what the court in Gibbs said is viewing the evidence as a whole and finding that the instruction should have been given in Gibbs as well as in Baker. So if the court is inclined to clarify Hall and Wright and Levy and Baker, that is the way to do it, because when we're looking at a lot of things, and especially at the appellate level, we're talking about the totality of circumstances. So I guess that's a roundabout way of answering your question, Your Honor, but
I totally understand it. Yes, I gotcha.
And if I could just continue with the evidence, there was Corporal Buchanan, Corporal Lowe, not to mention the defendant's own statements. And Mr. Coulter and I disagree about the import of those statements, but Mr. Smith had a prior heroin, PWISD heroin drug charge that had happened to him shortly before this incident, or at least he was convicted of it then. And essentially that, I lost my train of thought, I'm sorry. But essentially that we also have he made statements to the effect of he knew what the trafficking amount or the thresholds were in the state that would potentially increase his penalty for state crimes. So our interpretation of that was that he well knew the types of distribution weights that could get him into further trouble.
So let me ask you in doing this, because I think we could and should go through the evidence, but we clearly are not going to weigh that evidence, are we? You're not going to talk about how much he talked about, what supports distribution versus what possession is. That can't be the way we're going to do it. That sounds like a jury determination. So I'm wondering, should the approach be you should refute or say there's nothing here to show he should get the possession, whereas the defendant says you've got evidence here to show that this was personal use. And the question is, did that arise to the level that the judge should submit it? If we get into a weighing of it, we're going to talk, oh, yeah, he's got quantity, he's got this here, it's here, it's here. And then you got possession. Judge got discretion. He can go one way or the other. That's not the way it's done, is it? Isn't it more of determination from, and when you look at Baker and you look at Gibbs, you're focusing on what is the evidence that the defendant says gives rise because he's requested this instruction. So is there evidence to support that instruction?
So as part of, in answering that question, Judge, as part of the special agent, the expert witness's testimony, we got out on direct. We wanted to flesh that out. And we said, is it possible that this could be user weight? And he basically gave circumstances under which it could be to, as Your Honor would expect, remove the sting of that on cross-examination. Mr. Coulter also went under that. Also went into that with Special Agent Razik. And I guess my answer to the court's question is very simply this. Special Agent Razik said, well, yes, it's possible. It's hypothetical. In this case, it was a qualified answer. And he said, it's possible in the world of worlds, but it's not possible based on my review of this case. So we think that that leans more toward the totality analysis and doesn't put Mr. Smith's sentiment about lesser included consistently in dispute such that he can
that really crosses over question till you get into the ultimate question, and an expert does. Expert has a limited. They can give you their opinion as to what it is, but when it gets to this specific case, it's helpful to some degree, but ultimately that gets back into the trial judge and to the jury in this case, the weighing of it. And so when you say the expert says it's possible, it could be, you put that in conjunction with other evidence that he says they usually put them in bindles. They weren't in bindles for sale. He had no scales. He had no weighing paraphernalia on him, and he didn't have any money on him. And even where you come up with the drug paraphernalia, he didn't have anything like a spoon or syringe, which would indicate he's a user. But, when you go to say he's got a full crack cocaine pipe, that's back at the house. That's not on him. This is why these cases get different. And be honest with you, I don't know why we have such a different rule for drug cases than other cases. Why don't we just put the general law, how you determine a lesser included offense, and just deal with it in the same way? I realize the court had some interest in wanting to do certain things or going away, but the law should have some consistency in it. And here, I think you candidly admit it from the beginning, and I don't see how you can not say it. There is some serious inconsistency in our state and in the state of our law in this circuit when it comes to drug cases.
I'll say this, Judge. I think the district court did a very good job analyzing it with all the cases it had in front of it. The district court referenced Wright. The district court referenced Baker. And if that's the case, Your Honor, we can't say it would not be our position if he considered everything he possibly could have, including the evidence in this case. I don't think I'm going to fall on the sword and say the court abused its discretion under those circumstances. And that's
Mr. Also, isn't it true that a district court, Judge Wynn says, well, you're going into the jury's function, but isn't it true that a district court always has to assess the strength of evidence in deciding whether or not to give an instruction? That's what district courts routinely do. And in this case, you can start, dividing and conquering and just concentrating on this little piece of evidence or that. But the point is, it is a totality of a circumstances analysis. It doesn't just depend on the absence of personal use paraphernalia. It doesn't just depend on that. That is one of many factors. It doesn't depend purely on quantity, but that is also one of many factors. It doesn't depend exclusively on the presence of a firearm, but that is also one of the factors. It doesn't depend exclusively on the text messages that were being sent, but that was also one of the factors. And you have a district judge here that is taking a holistic view of the evidence here with respect to distribution and saying, as a matter of his observation of the trial and hearing of the evidence, that the evidence here points quite decidedly toward distributional activity. And, you know, it is a routine call. It is a routine call. And we cannot keep stripping away from trial judges the kind of superior perspective that they gain from being on the trial bench. It's happening way too often. And this is the kind of thing that district judges do every day, and they are very good at understanding the strength of certain pieces of evidence. They're not totally left on their own, of course, but they're veteran observers of these kinds of things. Judge Harris, what did you?
We can't hear you, Judge Harris.
Your Honor, I can't hear you.
I'm so sorry. I'm always trying not to make noise with my papers. Sorry. I'm just wanting to follow on Judge Wilkinson and talk about what the district court did in this case, because I do agree there's a lack of clarity in the law here. It would be good at some point to resolve it, perhaps to synthesize it in the way you suggest. But in this case, it looks to me, as you say, that the district court basically read our Hall opinion, said there's this conflict or tension, I think we called it in the law. Wright suggests you need affirmative evidence. These other cases say, no, it's sufficient. It's enough to get an instruction. If the evidence of distribution is sufficiently in dispute, and then applied that standard, the Hall standard, sufficiently in dispute, and said, under that standard, I am finding on the facts of this case, the instruction is not warranted. If we think that the sufficiently in dispute, no requirement of personal use is the sort of defendant-friendly standard that you could pull from our cases, then the only question, right, is whether the district court abused its discretion in the way it applied that standard to these facts, right? Is that the question in front of us?
In our view, it would be, and we asked this court to give due deference to that. And I think one thing that I might add is we're talking about a hypothetical user. We're not talking about any of the people in the car with Mr. Smith. We're not talking about Mr. LeGrand. We're not talking about Mr. State. So, and as I recall from Mr. Coulter's closing argument, when he was discussing the heroin and whether Mr. Smith knew it was there because they had just gotten out of the club and into Mr. Staten's car, he said, whoever possessed it. So I think that's also a fact that the court could take into consideration. It wasn't as if anyone in the whole case could be pegged as a user. And that just goes back to maybe this idea from Gibbs, which Baker looked at, is that it's more of a totality analysis. And there will be cases, as your Honor suggests, where users will be around or implements of user activity may be around, and in some cases not.
I don't disagree that the standard in Hall should be the law. Hall was an unpublished case. Did it create a standard that was different, or did it articulate something different than what's in the published opinions?
Your Honor, my reading on Hall is that it noted this. I think what Hall said was that Wright seems to depart from the principles we set forth in Baker, and said, in any event, we're not going to resolve that conflict because there were scales in the car, and to that panel, the scales were determinative. In much the same respect that we would say that the panoply of evidence available, the text messages, the defendant's own statements, the law enforcement officers there, the expert's testimony in this case, if there's a tipping of the scale, as it were, in Baker or I'm sorry, in Hall, where scale was enough, our view of the cumulative evidence would be that Mr. Smith was not entitled to a lesser included under the sufficiently in dispute approach.
Well, it becomes difficult when you got an unpublished opinion that says Baker is in conflict with Wright, and then it articulates something and then it goes unpublished, maybe because you can't really resolve disputes with another panel's opinion. It's part of why I say there's a problem here with our law in following it. And I do feel a strong, having been involved in the trial process for many years, a need for lawyers as well as judges who, before the trial court, to understand the clarity of the law. And we cannot escape as appellate judges the fact that we have written these laws, albeit maybe to the dissatisfaction of some judges to other judges, because everybody has different opinions. But when we ultimately, the law should have clarity, and to dance around it and pick out the cases we like even now, or to lift up language that more favors our position on it, doesn't resolve it. And it won't give you clarity. And that's probably why you, even as the prosecutor, are sitting here saying, it's not just the defense counsel, it's me too, trying to understand when to do this stuff. And, maybe there's a way we can clarify the law. But I'm not disagreeing with the force of abuse of discretion for the judges or for how the trial judges act. I'm really concerned about the law and what we have here, and how we, our aim is to try to resolve in our opinions. We don't want to say a court was wrong. We can't even do it. We can't overrule them as a panel. But then in the effort to try to resolve it, we write in nuanced ways to get around it by cherry picking little facts and lifting up that fact as significant in this particular case. There's something wrong with that. The law needs to be consistent. And this circuit needs to make this law consistent on these points. But I appreciate your candor in bringing that out. And I really appreciate the way you approach this case. It's a very thoughtful way. Baker may well be the way to go. You mentioned Gibbs, but Gibbs is a pretty strong case. And Baker quoted it. That language that quoted is, wow, that's not in this circuit, but it put it right there in front of us. So we need to resolve this, and we need to resolve it in a way so that lawyers as well as trial judges, because ultimately, we talk about trial judges and their hard job. Try being a lawyer when your license is at stake as a defense counsel for not doing something, or a prosecutor where you have to deal with reversals of this stuff, when you can get rid of this issue. The ultimate question is, if you give it to the jury, this issue, the lesser included, let the jury, if there's enough, the judge considers there's enough or not enough to do it. And then it's resolved. And we don't end up going back and forth on, well, you didn't put the lesser included offense up there even because of these other things. So my heart's out to you guys because you practice law. And while I'm very sensitive to trial judges, I know this starts in those law offices, in those prosecutors' office, of what to do. And we ought to help you by clarifying the law.
If I could conclude just with the point that if the court is inclined to rule adversely in terms of whether the district court abuses discretion on this point, I'd just like to put in a brief plug to say, to the extent the court has considered the other arguments, if there's any issue with the sufficiency of the evidence, then the lesser included instruction would only affect the possession with the intent to distribute heroin account and the 924C charge. And we'd ask the court to otherwise affirm the Title 26 offense and the 922G. Other than that, I'll rest on the briefs, Your Honors.
Mr. Also, isn't there a danger of trying to convert essential, factual, and discretionary issues into matters of law? Doesn't that work in the respective responsibilities of trial and appellate judges?
Your Honor, I'm sorry. Your microphone cut off at the very beginning when you said, "Isn't there a danger?" And then I couldn't hear a little bit.
Isn't there a danger of taking matters of evidentiary discretion and fact finding and other things and trying to make them into propositions of law, trying to do it all up here? Doesn't that work a sea change over time in the roles of appellate and trial judges?
Yes, Your Honor. And if the court, I know I'm well over my time now, but I'll try to answer that question as briefly as I can. The sea change for drug cases would be this. In almost every case, we, as a prosecutor, representing the United States, in almost every case when there are lower drug quantities, almost every case would have this issue in it. And so that's why we'd advocate for the Baker approach with a consistent emphasis on making sure that the trial judge knows that they have to, for the lesser included to be given, the defendant has to be consistently, that the defendant would be convicted of the lesser offense and not of the greater. So we, in the totality of those facts, we just wouldn't want a rule, as Judge Wynn, as you indicated, and you also, Judge Wilkinson, we wouldn't want the exception to swallow the rule, because this could affect a whole.
Well, just when you come back down to it, I cannot understand what in the world the district court did wrong here. And this is another thing, people that follow our law and use the whole question of sufficiently in dispute, and then applied the totality of the circumstances to it. The call here was so routine, and it was just the application of a standard of law to particular facts. That's all. Trying to get perfect clarity is like chasing a mirage. It's always just over the horizon. And at a certain point, you have to say, trial courts, what the general standard is. Now apply it to the facts of the case and bring your own expertise to bear. That's all that happened.
And Your Honor, if I could conclude, we think that's exactly what the trial court did here.
Mr. Coulter.
Thank you, Your Honor.
You have some rebuttal time.
Yes, Your Honor.
Are you abandoning your Fourth Amendment claim, or are you...
I'm not. I would like to address that briefly after I make a couple of comments. I'd start with a quote from United States versus Levy, which said, "Any rational dispute about evidence regarding distribution requires resolution by the jury." I think the trial court in this case did view the evidence and conclude that the evidence pointed decidedly toward distribution. But that's not the standard. The standard is whether the evidence was indisputable, and it was not. There's, as I said, Special Agent Razik said that 3.32 grams could be a user amount. It was not packaged for distribution. There was no scales, no money. That makes it disputable, and that's something the jury should have decided. With regard to the Fourth Amendment issue, we've exhaustively briefed that for the most part. However, since our briefs, the Fourth Circuit issued a decision in United States versus Cloud, 994 F. 3rd 233, and the government has submitted that as supplemental authority. As to, I would indicate that it affects Mr. Smith's case in a couple of ways. Number one, in that when the court analyzed the Cloud case, Cloud was never treated as a mere pedestrian, even though he was inside the hotel room when the police blocked in the Dodge Avenger. He was not in the vehicle at the time. He denied ownership. But it appeared, although it was never explicitly stated, that the court presumed him to have standing to contest the seizure. Similarly, in this case, Mr. Smith was in the convenience store at the time when the seizure occurred by a show of authority. Trial court found at least 7 to 8 officers were present and demonstrated an overwhelming show of force. The second thing is the Cloud Court's analysis of submitting to authority. It said that submission need not be explicit. It can take the form of passive acquiescence. As in the Brennan case, Mr. Smith remained where he was and waited for the police inside. With regard to reasonable suspicion, the court determined that the Detective Buchanan called in the wrong license plate number, but that his mistake was reasonable. Defendant would contend that it was not a reasonable mistake. The undisputed evidence was that Sergeant Flowers called out the correct license plate number to the street crimes unit members at an early stage of the surveillance, that Detective Mayo and Detective Buchanan's vehicle pulled within 6 to 8 feet behind the Impala that the defendant was a passenger in, that both had a clear unobstructed view of the license plate, and that Detective Mayo correctly saw the correct license plate number. We'd argue that that Detective Buchanan's mistake was not reasonable. The question is not whether his testimony was credible, whether it was an honest mistake. The question is whether it was a reasonable mistake.
Well, let me ask you about that, because that is interesting. You initially have the right license plate called in, and then ultimately, when you got the cars around him, I guess, he calls in the wrong one, misses out a letter, gets the readout, that plate does not match up with this car. As I understand, that becomes then the basis upon which the police officer can then conduct a stop of the car and a search of it.
That's correct. That's correct.
And so my question is there any, and I'm thinking about how significant it is if an officer calls in the wrong number and it identifies the wrong car, and then you can then proceed on as though now he's driving a car with a wrong license plate on it. Is it reasonable for an officer to rely on just that one statement, that's not the car, which I'm sure they do all the time, but is it reasonable? And that is the only reason you can stop, rather than asking, well, here's the license plate number, are you sure? Is this number here? And you're saying that doesn't match up. I mean, it seems like that's one sentence to do that, or because it's the basis to do something based upon you making a call in, and it is reasonable that someone can get that number wrong. But what's not reasonable is how you're going to treat it as though doesn't matter if I got it wrong, because I, in good faith, called it in, and that's what it is. You can say that later on. And that's the part about this. I mean, you want to try not to get in the business of police officers when they're making split-second decisions, but when that decision is the whole basis for you doing something that allows you then to not respect the constitutional rights of someone, it seems like to me it's a small step of some level of verification to do it. But I take it it's routine. This is how this is done. Is that correct?
Yes, Your Honor. And I'm over time. If I could briefly answer the question. Your Honor, there was, although they had plenty of, Detective Buchanan had plenty of opportunity to do so, he did not verify the license plate. Even when the car was seized, the officers did not verify the license plate initially. They went up to search the car, even though it was empty.
Well, but the whole question here was the antecedent question of standing, wasn't it?
Yes, Your Honor. And like I've indicated, that's why I think Cloud is such an important case.
All right. Thank you very much.
Thank you.
We appreciate both of your arguments and hope you have a pleasant weekend and afternoon. And thank you for appearing before the Fourth Circuit.
Thank you.
And, we will take a 5-minute break and then we'll head into our conference.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.